that she had stepped out on the marriage. Dad indicated that he had forgiven her. Then she had indicated she had stepped out several times from the time she filed for divorce until September.
Yes, Your Honor. Taylor Marie Beatty appears through Zoom, in person, and through counsel Sarah Newell.
May it please the court, Your Honor. Rick Thompson appearing on behalf of the respondent, Bryce Beatty, who appears in my conference room for this Zoom hearing.
Very well. Counsel, it was the court's impression initially that this matter would come before the court at this time for final hearing. Is this case ready for a final hearing at this time, resolving all issues, Ms. Newell?
Well, Your Honor, we would like to think so, but after talking with Mr. Thompson this morning, I don't think so. Although at the time that I filed the motion for default judgment, Mr. Beatty did not have an attorney. He now has one this morning, and I don't think that Mr. Thompson has had sufficient time to review our divorce decree yet.
Mr. Thompson?
Your Honor, Mr. Beatty, that is correct. Mr. Beatty, I believe he was served with a motion Friday.
Yes.
And I looked in the court. I had my secretary pull the court filings and what Mr. Beatty provided me, and I did not see I didn't see an attached journal entry. So I don't know what was being proposed, Your Honor.
All right. Well, we're just past the initial 60-day period. We're still relatively early on in the case. The court is inclined to simply continue this for status conference and possible final hearing if everything gets resolved. I'm looking probably a little more than a month down the line. I will just suggest Tuesday, October 28 at 9 o'clock in the morning by Zoom. October 28, 9 o'clock a.m.
Your Honor, that works for the respondent.
The hearing opens with tension already in the air. What was expected to be a final divorce proceeding quickly turns into a contested hearing when the father, Bryce Beatty, appears with new legal counsel at the last minute. His attorney, Rick Thompson, admits he's had less than 2 hours to prepare. The mother, Taylor Beatty, represented by attorney Sarah Newell, claims the case is ready for default judgment until fresh developments surface. The judge, realizing both sides are unprepared for final disposition, pivots. What began as a procedural divorce hearing is now an emotionally charged custody and safety dispute.
That also works for me, Your Honor. I will point out that there are no temporary orders in this case, and there has been an issue that my motion discusses. I don't know how you want to handle that.
What is the issue?
The issue is that up until, sorry, I'm pulling up my motion here, Your Honor, that after the divorce was filed in July, the parties had been doing shared. My client's father had been doing the daycare while the parties were at work. Then there was an incident on September 2nd. The father was sick. My client was over there watching the kids and had missed him. And it was father's parenting time. And she was over there and there was an incident. I have the video off of a Ring camera where she told him some information that he did not like. And he went out and basically beat the back end of her and his van with either a baseball bat or a board.
When Taylor's attorney speaks, the courtroom atmosphere shifts dramatically. She alleges a violent confrontation, a domestic assault that unfolded just weeks earlier. According to her, Bryce struck the back of Taylor's van with a bat or board and physically choked her during a confrontation in front of their children. The alleged attack, caught on Ring camera, led to Bryce's arrest and 2 days in jail. Now, with criminal charges pending, Taylor seeks sole legal and residential custody, supervised visitation for Bryce, and child support. The allegations mark a turning point, transforming a family disagreement into a potential domestic violence case.
And then he choked her. She called 911. Her and the kids went into a bedroom that had a lock. They took Mr. Beatty to jail for 2 days. His mother bailed him out. There has been some kind of initial hearing. The judge ordered him to leave her alone, and there has been no contact with, I mean, he has tried to contact her since he got out of jail. My client has not contacted him, and he has not seen the kids. So in my motion, I had asked for sole legal and residential custody with my client temporarily. If you were so inclined to let dad see the children, he could have some time at VEP here in Wichita at his own expense. She lives in Wichita, he lives in Rose Hill, and then asking for some child support effective August 1st, and kind of dividing the cars just temporarily. That's what we are asking for, since shared isn't going to happen now, and his criminal stuff is pending.
All right, Mr. Thompson, that's a lot for you to deal with here on relatively short notice, but are you in a position to respond?
I've had an hour and a half, Your Honor.
Bryce's attorney immediately pushes back. Thompson admits his client damaged the van, but insists it was his own property. Not a crime, he argues, since the vehicle is in Bryce's name. He denies any physical harm to Taylor, claiming she misrepresented the incident. Thompson portrays the couple as reconciling before the altercation, framing the argument as a breakdown in communication rather than abuse. He emphasizes that Bryce has been a good father and insists the children never witnessed violence. His request is clear. Shared parenting should continue, and the children should not be punished for their parents' personal conflicts.
And I will do my very best, Your Honor. I think I have a decent grasp of the facts, Your Honor.
Right.
If I may. The parties were reconciling. Mom was at Dad's Rose Hill home from Sunday until Tuesday. Mom had disclosed to Dad that she had stepped out on the marriage. Dad indicated that he had forgiven her. Then she had indicated she had stepped out several times from the time she filed for divorce until September 2nd. Dad denies that he caused any physical harm to Mom. Dad does not deny that he hit the van with a 2x6, Your Honor. Van is in his name. It's a marital property, but it's in his name. I don't do criminal law. I do not know if you can have criminal damage to your own property, Your Honor, but that's not for me to decide. That's not for me to advise my client, Your Honor. The children were not. They did not witness any of these things. They had been doing shared custody, Your Honor. It was an odd arrangement, 3 on, 3 off, just 3, 3, 3, 3, 3. And Your Honor, there has been nothing.
As the discussion intensifies, new issues emerge: missing property, ongoing communication, and blurred boundaries. The defense accuses Taylor of taking Bryce's business tablet, crucial for his off-the-books second job. The judge steps in decisively, ordering Taylor to surrender the tablet to her attorney's office for collection. Then comes a stern reminder to both parents. Communication must remain in writing, by email, text, or a parenting app. The judge forbids phone calls and third-party contact, especially given Bryce's restraining order from the criminal case. It's a precautionary step meant to prevent escalation and protect everyone involved.
Untoward toward these children, Your Honor. By all accounts, Dad has done a good job with the children. Mom had provided for shared access. We believe shared access should continue, Your Honor. Dad did 90% of the transportation when they're doing the shared. Mom had other priorities. So, Your Honor, we do not think that the children should be punished because the parents are not getting along. No contact order between Mom and Dad, which is fine. We have other folks that can facilitate transportation. Dad lives in the marital home at Mom's request. Mom is living with her father, the maternal grandfather, in a home where she is sharing a room with, I think it's the 1-year-old sleeping in, the 3-year-old sleeping in the same bed. So, Your Honor, we think that parenting time should resume between Dad and his children. No contact with Mom. We all think that's the best for all parties. As to child support, Your Honor, there is a number associated with the motion. There was not an attached child support worksheet. And I saw the domestic relations affidavit and it provided that my client was working a spirit.
Taylor S. attorney re-enters with devastating evidence. 2 videos allegedly capturing Bryce's aggression. The first shows him attacking her vehicle. The second, far more disturbing, depicts Bryce yelling at their 3-year-old son, believed to be autistic. The child cries as Bryce screams, a heartbreaking moment that silences the room. Taylor's attorney argues these videos reveal deep-seated anger issues that make unsupervised visitation unsafe. She requests mandatory anger management and therapy for Bryce before any shared custody resumes. Her plea is clear. The children are too young and too vulnerable to endure such emotional volatility behind closed doors.
Mom knew he was not working a spirit. As of the week she filed for divorce, he had moved over to Thrasher, Your Honor, which is a foundation company. He makes less money, but it's kind of his own business. And then we also have some personal property issues. When Dad was taken, Mom went to the house and took a number of items, including his tablet that he does his business invoicing, and she has texted him. So the communication is going from Mom to Dad. Dad knows he's not supposed to communicate with Mom, but Mom is communicating with Dad. Says, I have your tablet, and the judge is going to have to tell me to give it back or do it in the property owner. So,
Eric, can I say something?
Hold on, Taylor.
Okay.
No, not right now.
All right. Are you in a position to respond regarding what appears to be a work-related tablet, Ms. Newell?
Your Honor, I am not in a position to discuss a tablet.
So, Your Honor,
Perhaps your client wants to address it, since she kind of interrupted when that item was brought up.
If she would like to address it, Your Honor, and you would
No.
like to hear what she has to say.
Well, if
I
somebody
don't know
needs
anything
something
about
for
it.
work, they should have access to it. It's really pretty simple.
Clips, 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 slips, clips. The judge listens carefully, aware that the courtroom has turned from legal procedure to emotional turmoil. With conflicting stories and incomplete documentation, the court acknowledges the situation is a snapshot, not the full picture. Still, the allegations are serious, the videos compelling. The judge concludes that immediate protective action is necessary. Temporary decisions must be made not out of final judgment, but for the safety and stability of the children. Both attorneys brace themselves as the court prepares to issue emergency orders that could redefine each parent's role in their children's lives, at least for now.
I understand.
So how does that get transferred?
So in regards to that, that is with his second job, a one that he does do off the books. If you would like for me to try to get that to someone else, that's not an issue, but he has also been trying to contact me through third parties.
All right. Well, the one way that I know this will work, I'll instruct that Taylor Beatty deliver this tablet to her attorney's office, Ms. Newell's office. Mr. Thompson and or his client can make arrangements to pick it up from there.
Thank you, Your Honor.
All right. As far as custody, it's difficult for this court to address an issue of custody. There's no temporary order for this court to look at or interpret. Apparently, the petitioner in this case was willing to operate without a temporary order. If the father has a restraining order on him through a criminal case, is that correct? A bond restriction?
I believe so, Your Honor.
But no protection order?
There is no separate PFA.
Okay. All right. Well, the court will direct that the parties communicate only in writing through text.
In a decisive ruling, the judge grants Taylor sole legal custody, authorizing her to make daily decisions for the children's welfare. Bryce will receive a minimum of 1 weekly supervised visit at a designated exchange and visitation center at his own expense. The court emphasizes this is a minimum, not a maximum, encouraging gradual rebuilding of trust. The judge warns both parents. Failure to cooperate could result in custody being reconsidered entirely. The message is stern, yet balanced. The father must remain involved, but only within safe, structured boundaries while the emotional dust begins to settle.
Messaging, email, or perhaps a parenting app, any of those would be approved by the court. I think any face-to-face or telephone communication is not going to be in anyone's best interest right now. And I know that that does limit the parents to some degree, but the court wants to ensure that there is a record of communications between the parents both ways at this point. You should not be trying to use third parties except for your attorney, Mr. Beatty. Actually, that may be in violation of any restraining order that was issued by another court. So you need to be careful with that. But if you communicate in writing regarding the children or a child-related matter in a peaceful and non-harassing manner, it is necessary to promote the best interest of the kids to have interparental communication. So the court's going to allow it. But not if it violates some other's court's orders. So it's a delicate situation, but as far as this court's concerned, in this case, the communications between the parents for now need to be in one of those forms.
Your Honor, I don't know how you're getting ready to address the parenting time, but if I could respond just in a few sentences to what Rick stated.
As the gavel prepares to fall, the judge finalizes the temporary orders. No damage to marital property, no harassment, and full transparency in communication. Child support calculations are to begin immediately, with both attorneys tasked to finalize numbers by October 1st. A review hearing is set for October 28th. The tone softens as the judge reminds both parents that cooperation, not conflict, will serve their children best. This case, once about infidelity and divorce, has become a sobering study in the consequences of anger and mistrust, and the court's effort to restore order, one ruling at a time.
A few sentences.
Okay. I have video. I have not shared it with Mr. Thompson, that Mr. Beatty has an anger problem. And we would like Your Honor to give that much consideration. I have two videos. One, I have the video of when he beat up the car and screaming at my client. The kids were there at the house. They heard him beating up the car. It's not clear whether they saw it. I also have another video. It's probably the video that led my client to file for the divorce, where he is screaming at their 3-year-old autistic son. And again, the 3-year-old my client believes is autistic. He would take off his diaper and poop around the house. And the video is a camera from in the child's room, witnessing the father just screaming at him. He threw a piece of clothing at him. The kid got up and was, crying and left the room. It's very upsetting to watch, Your Honor. I understand that after that, my client allowed the father to have parenting time. Mr. Beatty had told her, my client would testify to this, that he told her the best she could do was 50-50, and she's not looking to stop shared. Maybe at some point they can go back to that, but she's asking for him to get some anger management and seeing a therapist or anything that he needs to see. But since the kids are 3 and 1, Your Honor, if he's doing this on his parenting time where nobody's watching him, there's nobody to report that to him. But between the two videos that she has major concerns about his 3 days on, 3 days off, because he goes to work early and so on and so forth. I am sorry that the journal entry and the child support were not attached to the motion. My client or my assistant says that I don't even know if they're filed, because she says she couldn't log on to eFlex this morning and see them. So I don't even know if Your Honor's been able to see them. They may have been filed and they're sitting in there for the clerk to approve. I'm not real sure. But if you're ordering my client to have primary, then we probably need to get some child support going.